then there are a number of executive orders by the president that are, quite frankly, out of bounds. They're constitutionally outrageous, if not preposterous. And I think it's important to realize that there are these three buckets.
In the same way that you might teach kids, hey, it's bad to be racist, it's bad to be sexist, so likewise it's bad to be homophobic, transphobic, etc.
Since when do the conservatives on the court care about anti-subordination models and footnote 4 of Caroline Products and political process theory?
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now I'd like to welcome our speakers, Professors Amar and Michael Dorf. I'll introduce them briefly. Michael C. Dorf teaches constitutional law, federal courts, and related subjects at Cornell Law School. He has authored and co-authored 6 books and over 100 scholarly articles and essays for law journals and peer-reviewed science and social science journals. He also writes a bi-weekly column for Verdict and publishes a popular blog, Dorf on Law, dorfonlaw.org, and he received his undergraduate degree and law degrees from Harvard. Vikram Amar is a distinguished professor of law at UC Davis and was previously the dean of and professor of law at the University of Illinois College of Law from 2015 to 2023. Amar has also taught at Berkeley School of Law, Hastings College of Law, now known as UC Law, and UCLA School of Law. Amar is one of the most eminent and frequently cited authorities in constitutional law, federal courts, and civil procedure. He has written several books and more than 60 articles in leading law reviews. He's the co-author of the upcoming revised multi-volume treatise on constitutional law, pioneered by Ron Rotunda and John Nowak. The webinar presentation that you're about to watch will be approximately 1 hour, and our speakers will be taking questions time permitting. So if you have any questions that you'd like to submit, please feel free to click the Q&A button in the control panel at the bottom of your screen and submit them there. Now, without further ado, here are Mike and Vikram to discuss key rulings of the 2024-2025 Supreme Court term, breaking down the bench.
Thank you so much, Nina. It's great to be here with Mike. I always learn from and enjoy being with him. And I think this is a great service that Justia is providing. You know, this time of year, guys like me and Mike get asked to do a lot of these so-called Supreme Court reviews, looking at the year that passed and maybe looking forward to what's coming up at the court. And I'm as court-centric as the next guy. I clerked for the Supreme Court just as Mike did, and I obsess over these opinions. But at this moment in U.S. history, I think it's important to locate the court in some kind of context and focus not just on the Supreme Court, but on the judiciary as a whole and our democratic institutions more generally. So, of course, we're going through a very unusual, unprecedented moment in government history. The new administration has issued countless executive orders, some of which are legally, permissible if politically contentious. I think a large number of the executive orders are lawful, even if they're controversial. Then others are kind of legally and constitutionally edgy. They present cutting-edge questions. And then there are a number of executive orders by the president that are, quite frankly, out of bounds. They're constitutionally outrageous, if not preposterous. And I think it's important to realize that there are these three buckets. As a result of the aggressiveness and the volume of these orders, the district court judges have issued, I think, over 200 injunctions, both preliminary and permanent, against various actions the administration has taken. And several of those, a handful or more, have been rebuffed by the U.S. Supreme Court, many in the so-called shadow docket context that Mike will talk a little bit about more later. But before one gets a sense that the Supreme Court is looking to rule in Donald Trump's favor, remember that the administration and the Solicitor General, Sauer, is picking and choosing which cases he wants to take to the Supreme Court from among these 200 plus losses in the district courts. So I think as a general matter, the Supreme Court is holding up pretty well. And although Mike and I might disagree with certain of their rulings, and maybe we disagree with each other on some of the rulings, I don't think the Supreme Court has done too much stuff that's really hard to defend, at least as to bottom line. But again, the Supreme Court isn't the be-all, end-all. Mike McConnell, a professor at Stanford, the other day did a New York Times podcast in which he expressed optimism based on the fact that he thought the Supreme Court was holding up pretty well, and the fact that the administration had yet to openly flout a direct Supreme Court order. And I think I agree that they haven't yet flouted a Supreme Court order, but I guess my point here is that there's lots of things that will never get to the Supreme Court. Think about the absolutely outrageous settlement, executive orders involving universities and law firms. If you ever represented a person that the president doesn't like, then you can't enter into a public building. Or Harvard, Mike's double alma mater, has to have ideological balance, whatever that means, within each and every department among the faculty it hires. These are clearly illegal demands by the administration, and yet universities and law firms are settling with the president. Why? Because not everything can find its way into court. And even if you win battles in court, you might lose the war, because there's lots of things a president and administration can do to injure you that are hard to prove are illegal in court. For example, the administration of grants, the award of international student visas. These are things that the administration has a lot of subjective selectivity to administer, and yet you can't always win on those soft power exercises. And as a result, presidents can get away with a law that is illegitimate and illegal because there's not always a Supreme Court there when you need it. If we look at the other guardrails outside the judiciary, I don't think a lot of them are holding up that well. Congress is really not much of a counterweight. I think we've seen that in the modern era. The media and universities are a powerful counterweight to presidential and governmental power. But as I mentioned, they're under siege. They're under attack. The American people, the ultimate guardrail, may be paying attention, but only intermittently. And so let me close my framing remarks with an observation about what I think is probably the most important guardrail, and that is the marketplace, the international markets. President Trump has pulled back from some of his most extreme actions, whether it's threatening to fire Fed Chief Jerome Powell, or the imposition of very extreme tariffs without clear congressional authorization. He's pulled back from these things when the equities and especially the bond market have gone haywire. When people are no longer willing to buy American debt and take American fiscal security as a given. And it's kind of ironic for somebody who doesn't like international entanglements, or purports not to, that it's the international financial markets that are ultimately the constraint on the president, and they're ultimately what cause a few Republican senators and Republican donors to peel off and put pressure on him to pull back. And so when Mike McConnell said that the president hasn't flouted a direct Supreme Court order, and I think that's probably true, although the administration has played fast and loose with lower court rulings, I think the reason for the failure, the government, the president's disinclination to take the Supreme Court head on, is if he defied a clear Supreme Court directive in a domestic realm where the Supreme Court was on sure constitutional footing. I think the markets would drop 25 or 30% in that single day, and I think everybody knows that. And so that's the ace in the hole. And so even though Mike and I are proud law school graduates, proud JDs, sometimes I wish I had gotten a master's in economics or an MBA, because I think in the real world today, those are as important in preserving democracy. Those perspectives are as important as doctrine is that the Supreme Court fashions, to which we'll maybe turn now in a little bit more of an earnest, because I don't want to dismiss the relevance of this highest court in the land.
First, I'll just say that I'm delighted to be back here with Vic, and I always learn so much from talking with Vic as well. I'll say one word about the market discipline, and then I want to say a few words uh, so further to the introduction, and then let's dive into some of the cases, and I'll try to tee up one of them for us. Uh, I agree that the greatest disciplining force so far on the Trump administration has been the bond market. Um, I toyed with the idea of writing either one of my biweekly columns for Verdict or from a piece for my blog on trying to figure out how to leverage that, like figure out other ways to get the discipline of the market to apply in contexts we don't ordinarily think about, right? So, maybe with respect to immigration policy or with respect to abortion or whatever. And perhaps had I gone to business school, I might have figured out some complex derivative I could have sold that would have done that. Or a meme coin or something, but I was unable to come up with any really good way to do it. And so I abandoned that idea. I will say that, insofar as the court does have authority with this president, I think I'm a little bit less charitable towards the current court. I think the best account of what the court has been doing, which is, after all, they've sided with the Trump administration in every case that's gone up there at this point, where the administration has sought to dissolve lower court rulings. And I take that with the huge grain of salt that Vic gives, which is that the administration is not appealing most of the cases; they're cherry picking. But still, you'd think that they would be a little bit aggressive in what they take to the Supreme Court, and the Supreme Court has sided with them in every one. They haven't written opinions in most of them. When they have written opinions, they've been sort of cursory. I think the most charitable thing you can say about what the court is doing is that it is keeping its powder dry for when it really needs it. That is, they don't want to be in open conflict with the Trump administration. Now, that's pretty extraordinary, given that this court has been very good for the current president, right? There were two landmark cases last term, not the one that just finished, but the one before that, right? In Trump against Anderson, they unanimously ruled that states couldn't keep him off the ballot during the primary season, or generally that you need congressional approval. And then in the immunity case, they gave him sweeping immunity against criminal prosecution. And even so, it seems like they don't have enough capital to spend some of it and say, hey, you can't do this, you can't do that, you've gone too far. Now, maybe that's because they think he hasn't gone too far. Maybe they think, on the merits or given the procedural posture, the administration should win. But I think that another way to see it is that Gillen Roberts is trying to marshal the prestige of the court and to preserve it. And he worries that maybe the markets won't discipline the administration. Maybe the president will defy a court order and doesn't want to lose that power. There's this famous apocryphal line attributed to Andrew Jackson after the Supreme Court ruled against him in Worcester against Georgia. John Marshall, then the Chief Justice, has made his decision. Now let's see him enforce it. It never actually happened, but that is a constant fear running through Supreme Court jurisprudence that, the court, as Hamilton says in Federalist 78, lacks the power of the purse or of the sword. And so it only depends on people accepting its decisions. And I worry that this court is bending over backwards to preserve its status with this administration and therefore not being as forceful in enforcing the law as I think it ought to be. But that's, I think, a good way for us to get into our first case, which arises out of, although it was argued, but it arises out of one of these cases that came up originally through an emergency posture. So I think Vic's going to talk a little bit about Trump against CASA.
Yeah, thanks, Mike. So let me just build on what you said and make offer two kind of slight potential qualifications. I think it's true that the court hasn't ruled against the Trump administration in any of these applications, emergency applications to review lower court relief. But at least in two cases, the first Abrego Garcia case, and in Wilcox, which I'll talk more length about later. That's the case involving the president's power in the meanwhile to fire NLRB, National Labor Relations Board members, and the continuing viability of independent agencies under the Humphreys executor case. In both of those cases, the court kind of in dicta, to be sure, went out of its way to kind of try to send a shot across the bow to the Trump administration. In Garcia, Abrego Garcia, they said that even under broad deportation powers, a deportee has to have the opportunity to bring a habeas action before being deported. And with respect to Mr. Abrego Garcia himself, the administration was under an obligation to, try to facilitate his release and return. And I actually thought the Supreme Court was a little bit ahead of its skis there, because telling a president to do anything in the international realm, I thought was pretty aggressive. And then in Wilcox, of course, even as the court allows the president to fire an NLRB member, it says, as you'll talk about later, I'm sure, they said you can't, don't mess with the Fed. The Fed is very different. So again, trying to reinforce the market's discipline with regard to Jerome Powell and the chair of the Fed. But let's talk about CASA. That's the case involving so-called universal injunctions that arose in the context of the president's executive order on birthright citizenship. Now, universal injunctions, and for these purposes, I'm going to define universal injunctions as injunctions that tell a government defendant, in this case the executive branch, and universal injunctions could apply to corporate defendants too, but for the most part they're controversial in the context of states and especially the federal government as defendant. So injunction that tells the federal government not merely to respect the rights of the plaintiffs who have sued, but to basically respect all other people who are in the same position who are subject to the same policy that the plaintiffs are complaining about. So it's an order that tells the president not merely to respect the rights of the plaintiffs, but to refrain from violating the Constitution with respect to this allegedly illegal policy more generally. And the Supreme Court in CASA says that as a general matter, federal courts have not been given the power by Congress or by tradition to grant relief that goes beyond that which is necessary to fully protect the parties who are bringing the claim and who have a valid entitlement to relief. So the remedy can't go beyond the plaintiffs. As a general matter. Now, sometimes the remedy has to go beyond the plaintiffs in order to fully protect the plaintiffs. A good example of that was Los Angeles District Court judge order a few weeks ago that told ICE not to racially profile anybody because that was the only way to protect the particular plaintiffs who sued and had an entitlement not to be racially profiled themselves. The only way that those folks can avoid being racially profiled is if ICE stops racially profiling everybody, since ICE doesn't know who those people are until after it wrongly detains them based on their race. So even under CASA, there are times when the relief can go beyond the plaintiff, but it can't go beyond that which is needed to fully protect the plaintiff. The court in CASA directed the plaintiffs to instead pursue a class action, a nationwide class action. In this case, the class would be made up of all persons who are entitled to citizenship under the 14th Amendment after they're born, but who are deprived of that under President Trump's executive order. And lo and behold, one of the district courts in which this birthright executive order is being litigated did in fact certify a class action. And I'm confident that the Supreme Court is not going to mess with that. I'm confident that the Supreme Court's going to leave that be. Now, let me just mention that there was a way in which universal injunctions were a big tool for plaintiffs challenging federal misconduct. And here's how. And Mike wrote about this, and I've written about this as well. Universal injunctions allowed plaintiffs to play a heads I win, tails you lose game against the government because you could have 100 different individual plaintiffs suing in 100 different lawsuits around the country. Even if the federal government won at the preliminary or permanent injunction stage on the first 99, if a plaintiff wins on that 100th one and gets a, quote, universal injunction, then every would-be plaintiff, including the first 99 who lost, they get the benefit of that injunction. So basically, the government has to win each and every case, whereas the plaintiffs have to win just one of dozens of cases, and then all of them win, even if they've lost all the rest of the cases. And that asymmetry seems inherently unfair in the litigation context. Now, but that asymmetry, I should say, had real-world relevance only if the executive branch would respect a universal injunction vis-a-vis non-parties. In other words, if a district court issues a universal injunction and says, don't mess with the plaintiffs, or for that matter, anybody else subject to this policy, and the federal government says, okay, we're going to respect the plaintiff's rights because we lost when we litigated against her, but we're going to still apply this against other people who weren't part of that case, the question arises, what can be done to enforce that universal injunction? An oral argument in the CASA case makes clear to me that there's precious little that can be done. Why? Because if you're not a party to the first case, you cannot bring a contempt action for civil compensatory relief. The only people who can sue for contempt in the civil setting are the actual parties to the case. And if you weren't a party to the case, but a beneficiary of the universal injunction, you might be harmed by its violation, but there's no contempt action you can bring. Now, what about a criminal contempt action brought by the judge who doesn't like his universal injunction being flouted? Well, unfortunately, the president might be able to issue a federal pardon for any criminal contempt proceeding that the district judge engages in. So there's very little that can be done if an administration is not going to respect injunctions apart from when they can be forced to via contempt. By contrast, a nationwide class action that's certified, in which all would-be plaintiffs are actual plaintiffs, because that's the way the nature of the class works, then all of them have the tool of civil compensatory contempt if the administration violates the injunction against the class. And unlike criminal contempt, civil compensatory contempt doesn't need the involvement of the president, because you could get a damage award against the officials who violated the injunction and enforce it with a judicial decree against the defendant's assets or wages that don't involve a federal criminal enforcement. So in a weird way, I think the plaintiffs are actually better off in many instances with a class certification than they are a universal injunction. So I'm actually not offended by the CASA result or the reasoning, except I think Barrett's historical analysis was a little bit wooden. One final point about CASA, and we'll come back to CASA later when we talk about the failure of the court to really engage the merits of the birthright citizenship issue, which it probably should have and which some dissenters did. But one big question left unresolved in CASA involves the Administrative Procedure Act and the so-called vacatur of agency actions that are held to be in violation of law. The court bracketed that issue, and we don't know whether those vacatures of agency actions will continue to have the same effect that universal injunctions did. But in a case like CASA, where it's the president and an executive order that he issued rather than an agency rule, I'm not sure the APA is that relevant, because the Supreme Court has held that the APA does not apply to the president simpliciter, only to agencies within the federal government, and the presidency is not an agency.
That's great. I'll just say a few words about CASA because we have a lot of the docket to get to still. So the one thing that I'll say that I strongly agree with is I share many of the critiques of universal injunctions, and the court in the beginning of its opinion goes out of its way to recognize that this shouldn't be, and generally isn't, an ideological issue, right? That is to say, when a Democrat is president, and this was true under Presidents Obama and Biden, Republican-aligned interests bring cases and get universal injunctions, and the Democrats hate it. And it's the opposite in the current configuration, right? So that the heads I win, tails you lose problem is there regardless of the ideological orientation of the case. The problem of forum shopping is there as well. And so there are real issues with universal injunctions. Here are my three concerns about the case. First, this issue has been alive in the courts for at least a decade now. And, there were prior opinions by Justice Alito, sometimes joined by Justice Thomas. Actually, Justice Gorsuch was the one who was most concerned about this, right? In which he said, hey, this is a real problem. And I agree. It's a little bit weird to cut back on this power during the administration of a president who's being super aggressive in testing and in many cases just exceeding the bounds of the law. So that's number one. Number two is I really don't like the methodology that the Supreme Court used. It's fine to say that universal injunctions are inappropriate because, they have all these problems, but the court's primary method is to rely on a precedent from an earlier case called Grupo Mexicano that says that courts of equity only have the powers given to them by Congress, or that courts of equity traditionally exercised circa 1789 when the Constitution was adopted. And there's no reason to say why that's so, right? That is to say, the Article 3 vests in the federal courts the judicial power. Doesn't say the judicial power shall be frozen exactly as it was. There are other contexts in which powers evolve. So I would have preferred if they sort of just addressed it functionally to explain, not on historical grounds, but on functional grounds, why this is not the kind of power a court should have. The third thing I'll say is, while I very much hope that Vic is right about the class actions, Justice Alito in his concurrence does suggest that he wants to be, tight on the class action requirements as well. Now, I think read fairly, Rule 23, which is the federal class action rules of procedure, does pretty clearly authorize class actions of this sort, but it is, in some circumstances, difficult to get class action certified. So there, I'm just going to have to, hope for the best. Should we move on to some other cases? Okay, so I'm going to talk next about what looked like at the beginning of the term was going to be the sort of biggest case on the docket, and it was still quite important. So this is a case called United States against Skrmetti, and it arises out of a law in Tennessee that is similar to laws now in a majority of states that bans what is generally known as gender-affirming care for transgender minors. The law bans surgery and certain hormone treatments and puberty blockers. The surgery provision was not at issue because gender confirmation surgery is virtually never performed on minors to begin with, and no one challenged that ban. But it was the provisions that were banned were the prescription of puberty blockers. These delay the onset of puberty, and certain hormone therapies, giving respectively male or female hormones to minors who were assigned respectively the opposite at birth. These are medications that have been approved for other uses. So to give an example of a puberty blocker, if you had precocious puberty in, say, an 8-year-old girl who is cisgender, you could give her the puberty blocker because early puberty has harmful effects. So a doctor in Tennessee could prescribe it for that because it's FDA approved for that. In general, if a drug is FDA approved, it can be prescribed off-label, but Tennessee banned the off-label use for minors who are transitioning. So it couldn't be prescribed for a transgender boy or a transgender girl, for that matter, who wants to avoid the primary and secondary effects of puberty to facilitate a transition. Okay, the law is challenged by parents of minors. The United States under the Biden administration gets involved. That's why the case is captioned "The United States against Skrmetti." And the lower court the district court partially enjoins the law, but the Sixth Circuit disagreed and held that the law does not discriminate either on the basis of transgender status or on the basis of sex. And therefore, under equal protection, only rational basis scrutiny applies. Now, the law and other laws could be and have been challenged on other grounds, most promisingly as a violation of parental rights to make decisions with respect to their children's medical treatment, but that wasn't at issue in the Supreme Court. The Supreme Court granted cert to decide only the question of whether this Tennessee law violated equal protection. It did so in the context of a preliminary injunctive relief, which Vic will talk about a little bit later. But the core of the question is, does this law discriminate on the basis of sex or transgender status? And the sort of obvious reason for thinking it does is that a doctor can prescribe the very same medication to a cisgender boy, but not to someone who wants the same drug to transition. And it depends on whether you're a boy or you're assigned male or female at birth. So it looks like it's both a sex-based classification and a transgender status of discrimination. And of course, in 2020, the Supreme Court, in a case called Bostick against Clayton County, had held that discrimination on the basis of transgender status is sex discrimination forbidden by Title VII. Now, that was a statutory case, but the logic would seem to apply here. Nonetheless, the Supreme Court, by a 6-3 margin, rejects the equal protection arguments for both transgender status and for sex, and says that the plaintiffs and the dissenters, the three Democratic appointees, are all looking at this in an artificial way. They say when you ask whether it's the same treatment, you don't just look at the drug, you just look at you also have to look at what the drug is being prescribed for. So it's not the case that a boy is being denied the same treatment as a girl when the boy wants estrogen and the girl gets it. If the girl is getting it for some hormone deficiency, but the person assigned male at birth is getting it because they're a transgender girl, because that's a different treatment. And that's the core of the opinion by Chief Justice Roberts. He says that you can't look at what the drug is in isolation from the condition it's being offered to treat. And therefore, this law doesn't discriminate on the basis of sex or transgender status. And the court relies on, in part, what had been, until recently, a very, very controversial Supreme Court decision involving pregnancy, in which the court had said, this is a case called Geduldig, the court had said that discrimination on the basis of pregnancy is not sex discrimination because not all females are pregnant. And so it's discriminating between pregnant and non-pregnant persons. And this was not at a time when we used the term pregnant persons because we recognize that some people who are non-binary or transgender could become pregnant. It was because that was just the court sort of formalism. So the opinion is sort of formalistic in rejecting this. And then they say, if it's just rational basis scrutiny, of course, the state has a rational basis for being concerned about the uncertainty of the medical science behind gender transitions, citing some the approach of some other countries. It's a little bit of an irony here that the conservatives are relying on what's being done in Europe and the UK, when some of the same justices have in other contexts said, well, we don't really care about what they do in other countries. We're going to interpret our own constitution and our own law. I should say that my own view is that some of the medical science is a bit uncertain, and you can make a case that maybe some of these treatments are more experimental than is warranted for a prescription, at least in some circumstances. But the court doesn't really rely on that because they're just applying rational basis scrutiny. And Vic and I have talked about this offline, right? The issue is not so much with the result, although I do take issue with the result, as it is to say we're just going to roll over, even though there's lots of good reason to think that the Tennessee legislature was motivated by transphobia. Okay, that's all I want to say about that case. I have another case coming up, but I think I'll let Vic pipe in on that one if you've got anything to add.
Yeah, just a few quick points. So first, yeah, the outcome could be justified. The court could have said, heightened scrutiny applies because this is a gender-based classification, but under intermediate scrutiny, where we're dealing with children and the science is uncertain, we're going to defer a little bit to the state. That could have been totally intellectually honest, a way to do it. But to say this is not a gender-based classification, when the law defines the different diagnoses for which drugs are or are not available in terms of whether someone wants to appear more like the gender, a sex other than they were assigned at birth, it's just very disingenuous. It's like if a drug was available to change the pigmentation of our skin, and generally speaking, you were allowed to either lighten or darken your skin for cosmetic purposes. But then the law said, but nobody can get access to this drug for the purpose of appearing to be of a race other than the race assigned at birth. We're going to say that's not race-based because it applies to everybody. That's just really, I think, kind of dishonest. And Geduldig, again, Mike described Geduldig as saying, pregnancy is not the same as sex. So a law that treats pregnant persons different than non-pregnant persons is not a gender-based classification because not all women are pregnant. Well, a law that gives black applicants a plus to law school is a racial classification, even though not all blacks apply to law school. In fact, only a very small percentage of blacks apply to law school. So Geduldig's reasoning is just bizarre. And again, now maybe the Geduldig result is right. Maybe it's fair to say that people shouldn't have to pay for other people's pregnancy in disability programs. I'm not quarreling with Geduldig's outcome, but the question is whether we apply a more serious test or not. Here the court says, well, men and women are different biologically, so we're not going to apply a heightened test. That's the cart before the horse. Men and women might be different biologically, which is why intermediate scrutiny might be satisfied, but it doesn't obviate the need to apply that scrutiny. One other point, and that is on the question of whether trans persons should be beneficiaries of heightened scrutiny. Justice Barrett writes an opinion that invokes John Hart Ely and Caroline Product's footnote 4 analysis. Is this a group that's been discriminated against historically? Are they defined by an immutable characteristic? Blah, blah, blah. Since when do the conservatives on the court care about anti-subordination models and footnote 4 of Caroline Products and political process theory? If that were the animating feature of equal protection doctrine, then you wouldn't subject affirmative action in the race setting to heightened scrutiny or strict scrutiny, because whites certainly aren't a powerless, discrete, and insular minority. So it's just very odd to me to see, I haven't seen that kind of invocation of footnote 4 analysis by conservatives since the late 80s in Croson, where O'Connor kind of tongue-in-cheek invoked it. And then the final point to make is, Mike, you're right that they lopped off the parental rights part of this case, which was litigated below. But it's interesting about why they did that. In Mahmoud, the case you're about to talk about, they lean heavily on the parental rights. I suspect, and Pam Garland said this, and I agreed with her when I did one of these with her, she's at Stanford, is it would have looked really bad for the court to consider and reject the parental rights claims in Skrmetti, but then accept them in Mahmoud. It would have been a bad look to contrast those two. So let me turn it over to Mahmoud for you to talk about Mahmoud.
Yeah, so Mahmoud is a case in which it's another case in which you've got a clash between what we might think of as LGBTQ plus equality and the sort of cultural issues on the other side. So Montgomery County, Maryland, in their public schools adopted an LGBTQ plus friendly curriculum, which consisted, as far as I can tell, mostly of buying some books that are less inclusive, having them available. In some cases, they might be read aloud, but for the most part, it's just it didn't look like this was going to be, replacing study of American history, or this was, a whole curriculum in the sense that we might think of, a mathematics curriculum or a social studies curriculum, but it was included in the curriculum. And some parents, they said, hey, we don't want our kids reading this because it conflicts with our religious values. Initially, the school board allowed their kids out, but as the number of opt-outs started to grow, they found it was very difficult to grant all of these opt-outs because they had to find alternative programming for the kids while they were not in class. If it was a class activity, was just becoming a logistical headache. And so they decided, no, we're going to include everyone's going to be a part of this. And, what's so bad? We're not telling you have to believe this. We're just exposing them to a certain way of thought and a way of, and inclusive in the same way that you might teach kids, hey, it's bad to be racist, it's bad to be sexist, so it's bad to be homophobic, transphobic, etc. The parents sue, and they lose in the lower courts, but they win in the Supreme Court. And what they win on is that they have a religious right grounded in the Free Exercise Clause to direct the upbringing of their children. Now, stated at that level of generality, there certainly is something to the parents' claim. That is to say, parents can decide what faith and what sect in which to raise their kids, if they're raise them in any religion. They can send them to religious school. They can even not send them to school at all. Two of the landmark cases in the early 20th century that established parental rights, not necessarily under the Free Exercise Clause, but involved parents deciding how to direct the education of their kids. Pierce against Society of Sisters, which involved parents sending their kids to religious school, and Meyer against Nebraska about being able to have the kids educated in a foreign language. What's fascinating about this case, though, is the parents are not asserting a right to children's religious upbringing by sending them to a religious school. They're saying, we get to send them to a public school, but if we don't like part of the curriculum because it's inconsistent with the religious value to inculcate in our children, we get to opt them out of that piece. So it turns what had been a kind of wholesale right to what looks like an a la carte right. And the court, there are a lot of steps to the court's opinion. Part of it is reliance on a case called Wisconsin against Yoder, which involved the Amish. But of course, that was a case in which the Amish didn't want to send their kids to school at all. It wasn't a case in which they were sending their kids to public school, but were selecting what would happen, what part of the curriculum they would get. Now, I wrote a piece shortly after Mahmoud against Taylor, in which I noted, it's not just the LGBTQ plus inclusive curriculum to which parents could have a religious objection, right? Think about a geology class that teaches that the Earth is 4.5 billion years old, or an astronomy class that teaches that the universe is 13 years old. Those are inconsistent with so-called young Earth creationism. Likewise, biology these days is taught using tools that we've derived from the Darwinian theory of evolution as refined since many scientists. Do parents get to opt their kids out of all of those? Certainly the court wouldn't want to say that this is limited to hostility to LGBTQ plus inclusivity. And so even though it's easy to think of this case as, yet another in the line of clashes between state and local efforts to provide some civil rights for sexual and gender minorities versus religion, I think its bigger significance is for what it says about the religion relative to the public schools. Because until relatively it was always a question of, well, what happens? What are the public schools allowed to do? But in terms of keeping religion out, now it's what are they required to do in terms of accommodating religion? And I think, either the court is going to have to come up with a bunch of really good distinctions, or they're going to have opened Pandora's box. Now, I will say that when the court gets to strict scrutiny, they say the reason that the county isn't allowed to do this is because they are granting exceptions to other kinds of classes, in particular to what's essentially sex ed. And so if you're granting exceptions in other contexts, it's discrimination against religion or against particular religions to deny them in this context. But, this move is almost always available in the recent cases involving religion. You find something that looks a little bit similar and you say, aha, you're doing it there, but you're not doing it here. And, it certainly wouldn't be in anybody's benefit, certainly not these plaintiffs' benefit, to say, well, the result is, well, they're not going to grant exceptions from sex ed anymore. Okay, so that's what I'll say about Mahmoud.
Great. Just a couple of quick points. First, just as I think Skrmetti was disingenuous in dealing with past doctrine on what it means to be gender-based, so too here, the very idea that you're entitled to accommodations is in flat tension with Smith, the 1990 case where the Supreme Court said we're out of the business of that. Now, Smith tried to preserve Wisconsin versus Yoder, the Amish case Mike referred to, but there's always been a tremendous tension there. And until very recently, people would have said, well, the Yoder's facts were preserved, but it wasn't going to be extended. And this kind of illustrates that that's not true. If they wanted to really drive a Mack truck size hole through Smith the way they did, they needed to reckon with Smith more than they did in this case, I think. So that's point one. Point two, on the question of the slippery slope, well, what other kinds of objections can be made on religious grounds? And I would have preferred this case to be decided on just parental rights grounds more generally rather than religion-specific grounds. The court did, Mike, try to draw a distinction at times, although it was murky, between exposure to things that might be upsetting versus normative kind of culture or value inculcation, which it characterized these materials as involving. This was not materials that simply depicted gay or trans people in society in the context of a book. It was part of a lesson to try to embrace or celebrate or accept that the plaintiff subjected to. So if we're teaching evolution or slavery, if we're teaching the facts about those things and we're exposing kids to that, there might be room for a distinction saying, well, those aren't normative presentations; those are just factual introductions and exposures, and that's why they're different. Now, there's another kind of concern that the school district had, other than that slippery slope, and that is how manageable it is to allow kids to opt in and out. And when it came to sex ed, they said it's very different to allow kids to opt out of a whole unit rather than to opt out of hearing anything normative that the parents might not like, just kind of as those normative observations might be infused into the whole curriculum. That means teachers have got to plan ahead. They've got to give notice to parents about exactly what's going to be said so that parents can exercise this opt-out notion. And then it's got to be just logistically feasible to let kids shuttle in and out during various parts of the day. Now, at the end of the day, I think that's where we're going to see how schools react. What are they going to do about this? And it's interesting to me, Mike, that in the context of a case that came up on a preliminary injunction, there are parts of the opinion, including the end, that doesn't simply say, okay, there's a strong religious interest here. You got to remand to apply strict scrutiny to see if there's a compelling government interest on the other side. They say there's no compelling government interest on the side. They shut down the merits altogether rather than simply saying the parents are likely to succeed on the merits. And that forecloses the schools, in this case, from demonstrating that opt-out is just not feasible, is not logistically manageable. That would be a compelling state interest. And I think it's very selective that the court resolves the merits kind of on a kind of conclusive basis here, when in the CASA case I talked about earlier, the completely outrageous executive order on birthright citizenship, and to refresh people's memory, it says if you're born in the United States, but your parents were here either unlawfully or lawfully but temporarily, parents who were invited here to become doctors and residents or grad students, you're not entitled to citizenship, in flat contradiction of the text and history of the 14th Amendment. There, the court, even though it's a pure legal question that doesn't require any factual development, they didn't resolve the merits. And in Mahmoud, where it's a question that does involve factual development that had not been completely undertaken in the context of a preliminary injunction, the court feels comfortable just closing the door altogether. So I think there's a lot of tension in these cases where the court is picking and choosing how conclusively to resolve the merits of a case.
Yeah, let me just say one more word about the exposure question, and then say something about what you just said. Then we'll go back to you for a little bit more. At the end of the part of Justice Alito's opinion for the Mahmoud, where he's explaining why this isn't just exposure, he says this, and I'm going to quote: "In any event, the board," meaning the respondent, "and the dissent are mistaken when they rely extensively on the concept of exposure. The question in cases of this kind is whether the educational requirement at issue would substantially interfere with the religious development of the child or pose a very real threat of undermining the religious beliefs. Whether or not a requirement could be characterized as exposure is not the touchstone." So I read him as saying, even if this were just exposure, there's a chance that could disrupt. And that's why I was thinking of these science cases. But in any event, I completely agree with you about the court sort of almost, adventitiously deciding when they're going to decide the merits and when they're going to leave off the merits. There was this Alexander Bickel had this idea that the court should exercise the passive virtues of some not saying too much, right? And that was subject to vigorous criticism by lots of people, most famously by Gerald Gunther, who described this as being 100% principled 50% of the time. So maybe this court has reasons for when they are and when they aren't going to reach the merits, when they're going to explain, when they're not going to explain, but reasons are not in any way transparent.
Good. And I fully agree with you that the court in Mahmoud purported not to put too much weight on this exposure normative line. I'm offering that as a line they may come back to and say, looking back on this case, that was doing more of the work than we might have fully acknowledged.
Let's hope.
To deal with the slippery stuff. Okay, let me mention just two other cases that came up in the shadow docket and an observation about each. And I think it reflects in part why the federal government and the president won a lot of cases in the Supreme Court in the shadow docket this year, because sometimes district court judges aren't careful, and sometimes the dissenting justices on the left side of the court aren't that careful. So Noem versus Doe involves President Trump's wholesale rescission of the CHNV program that President Biden had put in, created essentially out of whole cloth, to spare about 500,000 migrants from Honduras and Venezuela and other places for up to 2 years, not to deport them because they might not fare well in their home countries. So this was something that Biden created, and Trump wanted to undo it. And the justices seem to all either agree or concede that the president was likely to win on the merits, that Trump had the power to undo what Biden had the power to create. Forget that for a moment, because no one seemed to disagree on that. But the dissenting justices, led by Justice Kagan, argued somehow that the lower court injunction preventing Trump from rescinding this program was no big deal because the government wouldn't suffer any irreparable harm in the meanwhile. Just let the case bubble up through the normal course. And it seems very odd to me to say the failure to enforce a policy regulatory program doesn't visit irreparable harm on the government. Why do we have law in the regulatory realm unless its lack of enforcement is causing harm? And how is that harm not irreparable? If, for example, one of those migrants commits a crime there's no way to undo that crime. There's no way to fully kind of compensate the victim of that crime. If migrants take jobs from citizens, how do you value and undo that harm? So I'm not denying that there's irreparable injury on the side of the individuals whose lives are going to be disrupted, but there's irreparable injury on the part of the government as well. In the vast majority of cases, when a court blocks the government from doing what it wants, it is visiting irreparable harm on the government. Now, again, we still maybe do a balance of the equities and a likelihood of success on the merits, but to say that the government doesn't suffer any irreparable harm, as KBJ did, is really quite implausible. Although I point out that it's not until the CASA case that you have a square holding by 5 justices who say what I just said, that when the government can't enforce its laws, even for a period of time, enforcement delayed is like enforcement denied, and creates irreparable harm for society and the government. The court had never been actually explicit about that, I think because it was such an obvious point, but they said it in CASA. And you can imagine a few cases in which the government is really just trying to get some money from an individual. And if that money is placed in some kind of escrow account and the individual is going to pay interest, maybe the government isn't irreparably harmed by a delay in getting that money. But that's clearly the exception, not the rule. And then another case, Wilcox, the one we mentioned earlier involving the NLRB, there too, Justice Kagan in dissent really wasn't focused on the merits of Humphrey's executor and independent agencies, although she talked about that to some extent. But she had the very kind of counterintuitive observation that because Humphrey's executor, assuming it's on all fours, and I'm not sure it is on all fours, but assuming it's on all fours, Humphrey's executor has to be respected by the lower courts, and therefore the president can't flout it by firing an NLRB member until the Supreme Court itself overrules Humphrey's executor. Treating the president like lower federal courts seems to me problematic in general. And in particular, there's many settings in which the court is not going to get a chance to overturn its past rulings it no longer agrees with unless the president violates a statute based on those earlier rulings. So how are you going to get the case teed up? It's possible that somebody subject to NLRB power might challenge an NLRB rule on the ground that NLRB members are given unconstitutional independence. And that's, for example, the way the SELA law case got teed up. But why should a president who's constrained by independent agency statutes, why should he have to wait for the fortuity of a private party bringing that kind of a claim instead of being able to fire or threaten to fire somebody? So I think there too, I mean, Kagan and KBJ in these cases are just saying things that really don't make sense, which is why I think some of these cases come out the way they do in this lopsided statistical way.
Let me say a couple words about that, and then I want to say one other thing about Trump against Wilcox. So I certainly agree with you that this principle, which we get from a case called Rodriguez de Quijas, that lower courts have to follow Supreme Court precedent unless and until the Supreme Court itself overrules it, shouldn't apply to political actors. And precisely for the reason you identify. I wrote a column many, many years ago in which I sort of broke ranks with other people who at the time supported a constitutional right to abortion. And I said that I think it was South Dakota was entitled to pass a law that was unconstitutional under the existing regime if they had some good faith reason to believe that the court might change the law and this would tee up a test case. So I certainly agree with that. In Wilcox, right, this is the case where the court says that the lower courts were wrong to enjoin the firing or to say you have to rehire these independent commissioners. In Wilcox, part of the problem I have with what the majority did is they don't even mention Humphrey's executor. They describe Humphrey's executor obliquely as a narrow exception to the general principle that the president gets to fire people who exercise executive power. Now, that is a huge departure from what Humphrey's executor said. It's also a huge departure from what the court has said in other cases, even when it was narrowing Humphrey's executor. So in Morrison against Olson, which is a case upholding the independent counsel in the late 1980s, Supreme Court said, well, the issue is not what the nature of the power is, it's about how much power. So that was a recharacterization. So, it's in the nature of the job being an apex court to recharacterize your prior opinions. But it seems like you ought to have the decency at least to mention cases when you are completely reconfiguring them or confining them to their facts or sort of de facto overruling them. And that brings me to sort of the last thing I'll say about the shadow docket cases is it is remarkable to me how many of the recent cases have been decided without even issuing a couple of paragraphs explaining, the logic on which they're relying. Is it a procedural argument? Is it the substantive argument? Is it a combination? You don't have to give a full throated opinion, but at least tell us, give us a clue.
So a couple things about that. There's a New York Times article last week about this absence of explanation, and it quoted Justice Alito in a speech he gave, I think at Notre Dame, saying, unlike journalists, we have to be very careful about what we say because people hang on our every word. Now, I don't think that argues in favor of no explanation at all. I think it argues in favor of a minimalist explanation that the court that gives the court flexibility in the future to kind of go in different directions. So I think you're right that although I will say that the absence of explanation can be liberating to the lower courts in some instances, because if the court isn't saying what exactly was wrong about the lower court's action, maybe the lower court could say we assume that the court had a problem with only part of what we did, so we're going to continue to do the other part of what we did. Now, I'm not sure the Supreme Court's going to like that, but they can't have it every which way. Either they have to explain themselves, or they have to permit some creative, not defiance, but pushback from the lower courts. On the final point, I think you're right. In Wilcox, the court could and should have given the lower courts more credit under Rodriguez de Quijas. They could have said, we're going to reverse you, but that doesn't mean you did the wrong thing, because we fully understand why you felt constrained by Humphrey's executor, and we want you to feel constrained unless and until we move in another direction. Now, there's a complicated question about whether a court should be moving in a substantively different direction in a shadow docket setting rather than a fully briefed setting. But to the extent that you think a court can make law in assessing the likelihood of success, then they should have kind of praised the lower court even as they undid its handiwork.
Well, on that note, I think I'll just great for to be here again. It looks like we're out of time, so I think we're going to wrap. I'm sorry we didn't have time to get to any of the questions.
Thank you, Mike. Thank you, Nina.
Of course. Thank you both so much.
Nina, it looks like somebody asked about are there any written materials as well, so you can
Yes.
at the outset.
Thank you, Vic. So those written materials are going to be available on the webinar page. If you log into Justia Connect, you should be able to download those there. They will be available as long as the page is up, so feel free to access them there. We want to thank you all so much for joining us for another Justia webinar. Thank you so much, Vic and Mike, for all of your insights. And thank you all again. As I mentioned at the top of the presentation, if you're interested in staying up to date with developments in the court outside of presentations like these, you can always sign up for our Justia daily opinion summaries. You can select the jurisdictions and practice areas of your choosing at newsletters.justia.com and get those upgrades right to your inbox. Thank you so much for your time. Have a great day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.